Good afternoon. You're listening to Eye on the Valley right here on CIVL 101.7 FM, broadcasting to the Fraser Valley, broadcasting from the University of the Fraser Valley Abbotsford campus on the traditional and unceded territory of the Storo people. I am your host, Radit Atwal. I have a great episode for you today, an interview with Marina Saddai, an immigration attorney, and we will be talking about work permits and how newcomers to the Fraser Valley can obtain work permit and what kind of difficulties they're facing. From your legal standpoint, can you explain the key criteria and eligibility requirements for immigrants seeking work permits in Abbotsford and throughout British Columbia?
Oh, that's a good question. Often people come and say, I would like a work permit, and it's not that simple. They have to qualify for a type of work permit. And there are many, many different types. So one has to sit down with a lawyer or an advisor usually and figure out which one it is they're qualified for, if any. Many people want a work permit, but they're not qualified. And if you like, I can go into a little more detail as to the main categories of work. So in one group, employers have to show that they cannot find a Canadian to do the job, and that they are offering competitive wages. And sometimes it depends on the job, but sometimes those wages are quite competitive. This is not by any means lowballing Canadian wages at all, contrary to what some people believe. So if the employer proves, look, we have to have a foreign national do this because there's no Canadian, then they get what is called a positive labor market impact assessment, LMIA. So that's the employer's document when they get it. And if they're successful, they get that positive LMIA. Then the foreign national puts a copy of that into their work permit application, and they might qualify for a work permit on that basis if they're qualified to do that job. In the other group, it is all the other work permits that do not need an employer to get an LMIA. And now, this is further broken down into two groups. One is employer-specific, where the individual has to work for that employer in that location, doing that job, etc. And then there's a few open work permits. And open work permits, there's not a whole lot of them. So again, one doesn't get them just because they want them. They have to qualify. But that's why there's no employer listed. There's usually not a location. No particular occupation. The person is pretty much in the job market, just like a Canadian citizen or permanent resident for the most part. So there's those two categories, and in that second category with closed and open work permits, there's a long list of different types of work permits.
Like every other school, the University of the Fraser Valley has a lot of international students. Sometimes they come here to study, but they're actually looking to obtain a work permit. Well, what are the challenges for students that want to obtain work permit?
Yes, a lot of students are coming over. They picked a college, not usually a university, but a college, and they don't know that not all post-secondary institutions will allow them to get a postgrad work permit when they're done. So for the most part, any of the public institutions, the universities, they're safe. But IRCC, Immigration, Refugees and Citizenship Canada, has a list of designated institutions, educational institutions on its website, DLIs, designated learning institutions, I should say. And you just have to type into Google DLI, IRCC, the list will come up. And then it shows, you type in the institution name, and it'll say it'll show if it's on the DLI list. And then there's another column there that says, and if you can also get a post-graduation work permit afterward. So the University of the Fraser Valley, to my knowledge, most, if not all, of its programs are qualifying, but there are a lot of smaller, particularly private institutions that are not.
And in cases of work permit denials or complications, what legal avenues or strategies do you typically explore as an attorney for your clients?
Oh, that's getting to be a tougher and tougher question. In fact, immigration lawyers are having continuing legal education on trying to solve this issue. because the problem here is that the channels of communication with IRCC are largely being closed down. So it's very difficult to go back to IRCC and say, look, I think somebody made a big mistake on my work permit application because they said I didn't have the education for it, but my educational credential was in the application. Somebody just missed that. It's an obvious error. Please reconsider. They might not reconsider. I think a lot of my colleagues right now are, in many cases, correctly saying that asking for reconsideration is often a waste of time, but not always. IRCC is also saying now that if one asks for reconsideration, they'll only say something to the individual if they change their mind. So if they decide not to reconsider it, or they reconsider it and still decide no, their position now is that they're not going to tell you. So it's very difficult. So what we're doing more and more is that the federal court is getting flooded with applications for judicial review, trying to go to the court to get corrections made, when really it's a shame that IRCC is quite unresponsive to fixing these situations. But yeah, one more detail on that. Going to federal court for judicial review is not an easy thing in many cases, because one, it takes time and it costs money. Two, it's a two-stage thing where one has to show to the court first that there was an error in fact or in law. The officer got something wrong, or the reasoning doesn't make sense. And then the court says, we won't hear this case, we're not interested, or we will hear this case. Now, not interested, I should expand on that. If they don't really think there's a legal issue to argue, they won't hear the case. So one has to ask to go to court, wait for the court to say yes or no, and then if it's a yes, then go to court.
There's a lot of people that we hear from here in the Fraser Valley that say that their work permits got denied. What are some of the misconceptions when people come to Canada and then apply for work permits that they don't know that they might have to face?
If they didn't follow the rules on their work permit, quite often people, get their work permit and they're sort of blind to it. Oh, I've got my work permit, I can go to work. Read it. Make sure you know all the rules about working in Canada and what you can and can't do. So not following the rules can make it very difficult, if not impossible, to get an extension, another work permit. Oh, a big one is that sometimes people put in a permanent resident application, and they think just by virtue of putting in the permanent resident application, that extends their work permit. That's false, absolutely false. If one has a permanent resident application in, they have to still look after their temporary residence as a worker, a student, or a visitor in the meantime, so they stay in status while their PR application is being processed. And other than that, the main thing is a lot of people don't know how to communicate their evidence that they are qualified to do the job. So, for example, a big one is sometimes language. They don't know really that they should be putting in some evidence of their language skills, or they think their language skill is high enough, and it's not. That's a somewhat common one.
Thank you for listening to Eye on the Valley right here on CIVL 101.7 FM with your host, Sergine Atwal. Join me again next week as I have another great episode for you. This program was sponsored by the Local Journalism Initiative.